Hi, good morning, colleagues. I've given you sharing rights.
Good morning. Is it Gershwin?
That's right, Mr. Markham. Well,
Yes, how
Kulubet,
are
how
you,
you
sir?
doing? No,
I'm
well,
good,
thanks.
thanks. Yeah, let me try to share. Please let me know if it is appearing.
Yes, it is. You can just make the resolution a bit higher.
Yeah, let me do it from this page.
That's great.
Is it okay this way?
Yeah, that's great. Thanks.
Okay. No, thanks a lot, Ne.
All right, see you after 10. Bye.
Okay, sure, thanks.
Hi, Gershwin. This is Alison Bota. How are you?
Hi, Alison. How you doing? I'm well,
I'm well,
thanks.
thanks. That's great. Gershwin, could I also just test my screen?
Sure, please go ahead.
Sure.
We'll be dealing with the divorce first.
Okay. Thank you. Just a sec. Is that visible?
Yes, it is. Might just want to make it one page view and just increase the resolution, please.
Sure. Is that better?
I still see two page view. I'm not sure what the issue is.
When you say two-page view, so my page is a landscape.
Okay, I'm seeing it in portrait, but it's showing both page one and page two next to each other.
Oh, strange. Okay. Does that help?
No, I see your screensaver. You want to maybe just try it again, just switch it off and
Sure. Thanks.
perfect. There, I can see it now. One page and the resolution is great.
Oh, great. Thank you so much.
Thank you.
Recording in progress.
Good morning. Opportunity to welcome you to this meeting, especially this being the first meeting that the committee will be holding in for this year, 2024. Welcome, honourable members. I know that the Deputy Minister and officials from the Department of Justice and Constitutional Development are also on the platform. Welcome to yourselves, but also a welcome to the Parliamentary Legal Services as well, who are present. Members, just in terms of apologies or attendance rather, we have Honourable Maleka, Honourable Ndongeni, Honourable Dudovu, Honourable Mikulakis, Honourable Badenhorst, Honourable Smith, Honourable Dlamini, and Honourable Bartlett is also expected to join us. She was on a flight which has just landed, and she has called. Welcome, honourable members. We have an apology only. We've received only one apology from Honorable Dengo, and I take it that our members that have not apologized would also join the meeting. That being said, our members, in terms of our meeting today, we have two agenda items. The one being getting a briefing from the Department of Justice and Constitutional Development on the public submissions received for the Divorce Amendment Bill, as well as a briefing on the public submissions received for Cannabis for Private Purposes Bill. That being said, honourable members, in terms of the first agenda item, the Divorce Amendment Bill, members will note that the last meeting that we had in relation to this bill was on the 15th of November 2023, where we received a briefing on the bill from the department. And just to recap on members, that the bill amends the Divorce Act 70 of 1979 to give effect to the Constitutional Court judgment in Women's Legal Centre Trust versus the President of the Republic of South Africa and others. And the Constitutional Court deadline on this bill is the 28th of June 2024. On members, the bill was advertised for written public comment from the 15th of November to the 5th of December 2023. The committee received 5 submissions, one from an individual, another on behalf of Senzo Kutle Advice Center, as well as from Nihau, the Women's Legal Center, and from Kusatu. Members would have received documentation as well in relation to the department's responses to these submissions, as well as, I think, a research note as well. Let me then request the department to then take us through their responses in terms of the submissions to the committee on the Divorce Amendment Bill. That being said, let me hand over to Deputy Minister to start the process. And thereafter, on members, after the briefing, we will then allow members to deliberate. Deputy Minister, over to yourself.
Thanks very much, Chair. Good morning to you, and good morning to all the honourable members. And may I wish everybody the best for the new year that we're in, 2024. You've received the report from the responses from the department. I think the departmental team is led by Chief Director Sebela Mecha. So I'll hand over to him to say which official will be taking everybody through the report. Thanks very much.
Good morning, Honorable Chair, and thanks to DM and honorable members. The DDG Kale is here, but the presentation will be done by Ms. Alison Guraka. She could be given the sharing rights so that she is able to make a presentation on the responses. Thank you.
Sorry, just to say, Chairperson and DDG Pillay, I hadn't noticed you in the meeting, so my apologies I should have referred to you, not to your Chief Director, but my apologies for that.
Gershwin, does Ms. Bertha have, okay, sharing it, okay, thanks.
Thanks, Chair. Good morning to you and good morning to the members. I just want to confirm that my screen is visible and that I'm audible.
Yes to both.
Thank you. I will jump straight into it. These are the comments that we had received on the Divorce Amendment Bill, and I'm going to go through the specific comments on the bill that were received So go through the comments and then go through our proposals and our responses. Clause 1 of the bill is the definitions clause, and the definition inserted is that a Muslim marriage means a marriage concluded, or rather entered into or concluded in accordance with the tenets of Islam. Nahau have commented on the bill, and they have said that the insertion of Muslim marriage is accepted, but that tenets of Islam is vague. There are 7 widely recognized sects or denominations of Islam, each with their own comprehension of the Quran, and this includes their interpretation and practical application of Sharia law as it relates to marriage. The Women's Legal Centre, or WLC, have commented to say that they welcome the simple definition proposed by the bill for a Muslim marriage, and they submit that the language will simplify the implementation of the legislation and make it easier for women to identify themselves in the legislation. The department has responded to say that we have chosen to define a Muslim marriage as broadly as possible to cater for each denomination's interpretation of the Quran. The department has decided not to define a Muslim marriage with reference to Sharia law or another more detailed definition that would in turn need to be defined. To avoid religious entanglement and defining strictly religious terms, which might be capable of multiple meanings, we've opted for the phrase tenets of Islam because it's broad and it covers a multiplicity of meanings. Also, the definition is sufficiently clear if we look at the dictionary definition meaning of tenet as a principle or belief, especially one of the main principles of a religion or philosophy. So this would capture any and all sects or denominations in Islam and any person who practices Islam. The definition will also assist with interpretation and implementation of the Divorce Act, so that all persons who identify as Muslim can find application. Further, the department doesn't seek to define a Muslim marriage prescriptively because this would stray into the administration of the Department of Home Affairs by attempting to regulate or specify the requirements of a valid marriage. The Department of Home Affairs, we're of the view, is best placed to define this term in legislation, regulating the validity and registration of marriages, as opposed to the department in legislation pertaining to the dissolution of a marriage. It's also to note that the Department of Home Affairs is currently working through its marriage bill in Parliament, and that would cater for a more comprehensive definition of that term. Clause 2 of the bill amends Section 3 of the Divorce Act by including the words, including the Muslim marriage, and allowing for a Muslim marriage to be dissolved in terms of the Divorce Act. Nahau have commented on the bill to say that the amendment by inserting Muslim marriage is accepted and consistent with the Constitutional Court judgment, highlighting the contradictions between the Divorce Act and Sections 9 and 10 of the Constitution. The WLC have also commented, and they support the inclusion and extension of Section 3 of the Divorce Act and the inclusion of a provision to dissolve Muslim marriages in the same manner as other marriages in South Africa, in line with the WLCT case. They're of the view that it will ensure legal certainty in respect of its application and the extent of the protection that the recognition provides for being able to access the divorce courts. The department notes the comments and agrees. Clause 3 of the bill amends Section 6 of the Divorce Act, and it provides for the extension of the safeguarding of interests of minor and dependent children of Muslim marriages. It amends, like I said, Section 6 of the Divorce Act by substituting paragraph A in subsection 1 and includes the words including any minor or dependent child of a Muslim marriage, and in subsection 3 by the inclusion of the same words. Nahau have commented on this clause and have said that the amendment of Section 6, subsection 1 and 3 of the Divorce Act is accepted as it speaks to the provision of the safeguarding of interests and rights of dependent and minor children. The WLC have also commented and say that they welcome the amendment of Sections 6.3 and 6.1 of the Divorce Act to ensure recognition and protection of the rights of children born from Muslim marriages. The amendment is warranted and will ensure the recognition of children's rights to equality and dignity, and will provide them with remedies and protection in law as envisaged by Section 28 of the Constitution. Also enable courts to make determinations in the best interest of children born from Muslim marriages who thus far have not had the benefit of this protection. The department notes the comments and agrees. Clause 4 amends Section 7 of the Divorce Act, and that provides for, It provides for the insertion after subsection 3 of the following subsection, which is 3A. A court granting a decree of divorce in respect of a Muslim marriage may, subject to the provisions of subsection 4, 5, and 6, on application by one of the parties to that marriage, in the absence of any agreement between them regarding the division of their assets, order that such assets, or part of the assets of the other party, as the court may deem just, be transferred to the first mentioned party. Effectively, it provides for redistribution of assets on the dissolution of a marriage. Now, I have commented that the amendment is accepted. The insertions into the subsections satisfy inconsistencies in terms of Section 28.2 and 34 of the Constitution. The insertion of Section 3A addresses the highly unequal and unconstitutional manner in which the dissolution of a Muslim marriage prejudices women and children in terms of the division of assets and benefits accrued during the marriage. WLC have also commented and say that jointly accumulated assets in Muslim marriages are often registered in the name of the male spouse. It's critically important to ensure just and equitable distribution of assets in keeping with principles of substantive equality. For many Muslim spouses, there's no formal written contracts entered into at the solemnization of marriage. Most often in practice, they find that couples have not concluded any agreements, and because of that, non-recognition and patriarchal influence in marriage, property and assets are in the name of the male spouse. The WLC welcomes the inclusion of provisions that will enable a wife to claim assets and property accumulated during the marriage and held under her husband's name in divorce proceedings. The department notes the comments and agrees. Clause 5 amends Section 9 of the Divorce Act, and it provides essentially for the forfeiture of patrimonial benefits on the dissolution of a marriage. So Section 9.1 is amended in the bill as follows, by including the words, including a Muslim marriage, in Section 9.1. Nahau have commented on this clause, and they are of the view that the amendment is accepted as it satisfies the previous inconsistencies in the Divorce Act pertaining to Sections 9, 10, 28.2, and 34 of the Constitution. The insertion of including a Muslim marriage underscores the judgment of the Court in the WLCT case, in that it addresses the failure of the Divorce Act to provide for the forfeiture of patrimonial benefits on the dissolution of a Muslim marriage vis-a-vis other dissolved marriages. WLC have also commented on this clause, and they welcome the inclusion of provisions related to the forfeiture of benefits, as they're aware that in many instances, because Muslim couples are not recognized in law and have no legal recourse available to dissolve their marriages, many Muslim women have been left destitute and forced to fend for themselves and their children with no support from their spouses. Women in many instances have been unable to obtain a religious dissolution of their marriage and have, as a result, been forced to remain married. In these instances, it would not be just and equitable for husbands who have transgressed in this manner to benefit from assets or property which may have been accumulated during the relationship. The extension of forfeiture of benefits is therefore welcomed in such instances. The department notes the comments and agrees. Clause 6 of the bill provides for the application of the bill, and it provides that this act applies to all subsisting Muslim marriages, including a Muslim marriage which was terminated or dissolved in accordance with the tenets of Islam, and where legal proceedings for the dissolution of the said marriage in terms of the Divorce Act have been instituted but not yet finalized, and B, which subsisted as at 15 December 2014. The WLC have commented on this clause, and they welcome the application of the amendments to ensure the protection of Muslim marriages, including those that have been dissolved religiously. They are concerned that the provision relies on women who have had their marriages dissolved religiously to have obtained legal representation and instituted legal proceedings, even though no court was in a position to have granted them a legal divorce. They submit that the department is not compelled to duplicate the limited retrospective approach taken by the Constitutional Court in the interim relief order which it made. The legislature can extend the protection of this legislation to effectively ensure it addresses the legacy of discrimination. WLC is of the view that the constitutional violation is so onerous, the women affected so vulnerable, and the period which they have been the victims of deprivation of rights so lengthy as to justify the immediate relief retrospectively to 27 April 1994 to the widest group possible of women. They submit that the state's opposition to this is to limit unintended consequences which are not clearly articulated, and that those can be dealt with by a court. They submit that the unintended consequences are exaggerated given the size of the Muslim population and those who may need to seek relief from a court under these circumstances. They submit that there have been no major unintended consequences, and where there have been, these have been dealt with by a court. They refer to the Recognition of Customary Marriages Act, and that it has affected many more couples than the bill will, because the Muslim population is so much smaller. They state also that retrospectivity in cases involving the validity of marriages and their propriety consequences are neither complex nor novel. Courts have repeatedly, in the context of customary marriages in Gumede, Ramovi, and AS, dealt with such matters, recognizing the substantive impact of historical discrimination. The department's response is that on the issue of retrospectivity, the department agrees and is of the view that the bill, and thus the Divorce Act, should have retrospective effect for the protection of Muslim women and children on divorce. The department recognizes the need to protect and promote the rights of vulnerable women and children, and for this reason, we've suggested the insertion of this clause, and that directly provides for retrospective application. So the issue is thus not whether the bill, and thus the Divorce Act, should have retrospective application. It should. The issue is until what date the retrospectivity should apply. The department has tried to balance the rights and interests of Muslim women and children and the rights and interests of other parties who will or may be affected by retrospective application. And paragraph 78 of the WLCT judgment is particularly helpful on this issue, where they dealt specifically with the retrospectivity issue. I will just quote or read the sections in bold. However, given the rights of third parties could be implicated by the relief, I deem it necessary to strike a balance. The interests of women who prompted and supported this litigation, but whose marriages terminated before the order of this court, will therefore also be catered for. However, this approach will also ensure that third parties will have effectively been placed on notice that relief was being sought on behalf of the class of persons to whom relief will be made available. You will see that the paragraph of the case which I just read is replicated in sections, or clause 6 rather, of the bill. The department does not agree with the suggestion to make the bill retrospective to 27 April 1994 because it's not as simply and easily done to make legislation retrospective as suggested. The application of case law in terms of customary marriages doesn't find application to the bill because the bill is applicable to marriages which no longer subsist because they have been dissolved. The cases related to customary marriages all apply to subsisting marriages. The bill applies to marriages which have already been dissolved, albeit not civilly, as well as to subsisting Muslim marriages. It's noted that arguments for the retrospective application of relief to 27 April 1994 were rejected by both the SCA and the Constitutional Court in this WRCT case after careful deliberation, with the court citing limiting retrospectivity helps to avoid the dislocation and inconvenience of undoing transactions. The department has attached a research note on the retrospective application of legislation, and that discusses this issue more fully. And this same research note was submitted to the Portfolio Committee as part of the department's responses to comments made in that committee. I'll just move on to the general comments on the bill. We had a comment from an individual, Tal, and that was a brief summary of the bill. The comment is noted, but it has limited usefulness for the purposes of strengthening the bill. There was another comment also from Senzo Kushle Advice Center, and they say that the bill is largely progressive in protecting the interests of minors as well as women within the Muslim communities, but that the bill should revisit the Recognition of Customary Marriages Act 1998, and in particular, Section 7 and 8 of that Act are not included in the current Divorce Act. They note that the dissolution of customary marriages is addressed in that Act and contain that there's a need for it to be included in the Divorce Amendment Act that we envision. Section 7.2 of the Recognition of Customary Marriages Act is also misused by different parties seeking to exploit people, and they've seen that not all marriages are concluded in good faith and that the requirements for a customary marriage are to be considered valid are constantly changing. As such, they propose that all marriages concluded under customary law should be out of community of property unless the parties register it accordingly. They also say that the bill should establish an act or include the marriages concluded under Muslim tenets in existing legislation, such as the Matrimonial Property Act 1984. The department notes the comments. As to the inclusion of Sections 7 and 8 of the Recognition of Customary Marriages Act in the Divorce Act by inclusion in this bill, the department's of the view that it is unnecessary, given that the Recognition of Customary Marriages Act in Sections 7 and 8 already refer, respectively, to the proprietary consequences of customary marriages and the dissolution of customary marriages. Those provisions, in turn, refer to the application of the Matrimonial Property Act and the Divorce Act to customary marriages. So, in other words, the Divorce Act does not need to be amended to specifically include Section 7 of the Recognition of Customary Marriages Act, because the Divorce Act and the Matrimonial Property Act already apply to customary marriages and are specifically referred to in those sections of the Recognition of Customary Marriages Act. As to the default matrimonial property regime of matrimonial proprietary regime of customary marriages and the requirements for a valid customary marriage, this would fall into the administration of the Department of Home Affairs. The department cannot amend that act, therefore. Regarding the inclusion of Muslim marriages in existing legislation, such as the Matrimonial Property Act, it's unclear what other existing legislation is being referred to. In relation to the inclusion of Muslim marriages in the Matrimonial Property Act, the department is of the view that an amendment of the Matrimonial Property Act is not necessary in light of the WLCT case and the issues raised and discussed there that have led to and informed this bill. Also, the department cannot prescribe the default matrimonial property regime applicable to Muslim marriages or indeed any marriage. The provisions of the Matrimonial Property Act apply to any marriage which is entered into, and so it applies equally to any marriage, thereby necessarily including Muslim marriages. Further, insofar as the definition of a marriage is concerned, the Department of Home Affairs Marriage Bill proposes a broad definition that would necessarily include a Muslim marriage. COSATU have commented that they support and welcome the bill and that it is long overdue, and it seeks to enhance the protection of women and children of Muslim marriages during divorce, separation of assets, and custody proceedings, and must thus be supported. They urge Parliament to ensure the speedy passage of this progressive bill. I believe that an overhaul of marital legislation is necessary and overdue to ensure the full recognition of Muslim marriages. They support the calls for a comprehensive overhaul of our marital laws, catering for all faiths and traditions, to ensure that all married parties and their children enjoy their full constitutional and legal rights, and none are left disadvantaged. They support the bill, among others, because it is constitutionally necessary and it protects the rights of women during divorce proceedings. They recognize that women are vulnerable during divorce proceedings for a variety of historical, legal, patriarchal, socioeconomic, and other reasons, and that women and children are routinely placed at risks of hardship during divorce. The bill is a progressive step forward to protecting the rights of hundreds of thousands of Muslim women and children. The department notes the comment and is cognizant of and alive to the issues raised. As referred to above, the Department of Home Affairs Marriage Bill is an overhaul of the current marriage laws, and it recognizes standard requirements for all marriages, thereby recognizing all faiths and traditions. Naharu have commented that the bill is only one important step towards a greater need for reform in marriage laws. South Africa's persistent patriarchal character found resonance in the outdated Divorce Act through the non-recognition of Muslim marriages. The department notes the comment and is cognizant of and alive to the issues raised. The WLC have also commented and speak to the importance of the legislative amendment. The present vulnerable position of Muslim women upon dissolution of a Muslim marriage by talaq is self-evident. Women are often left with a virtually non-existent proprietary estate and sometimes completely destitute upon a talaq being issued. This, coupled with the responsibility of childcare and none of the statutory safeguards afforded to other similarly placed women, means that these women are left without legal protection and remedies in law. This is more so when they're not sufficiently empowered to exert their rights, to negotiate and contract the terms of their marriage at its inception, as is often the case of the poor and most vulnerable of society, or where they live in communities in which patronizing and patriarchal attitudes may still prevail. It is our experience in consulting with all Muslim women that assets acquired during the marriage are acquired in the husband's name and accumulate in the husband's estate. In the absence of legal recognition, Muslim women have no remedy to obtain an equitable distribution of their husband's assets or a forfeiture of benefits, in that provisions such as Section 7.3, read with Section 7.4 and Section 9.1 of the Divorce Act, are not at their disposal. That economic hardship is compounded by the reality in that it is Muslim women who are most often the primary caregivers of children and left with their care upon the termination of the marriage. Muslim women in South Africa experience compound forms of discrimination, materially different to their counterparts under civil marriages. These result in overlapping burdens that lead to excessive hardship for Muslim women. Given the intersection of various grounds of discrimination, Muslim women are particularly vulnerable and marginalized, both historically as well as contemporarily. They suffer multiple yoke of oppression based on marital status, gender, sex, religion, and class. The department notes the comment and is cognizant of and alive to the issues raised. Thank you, Chair. That brings me to the end of the comments and the department's responses on the Divorce Amendment Bill.
Thank you very much, Ms. Botha. DM, do you have any comment you would want to make before members engage on the presentation?
Nothing at this stage, Chairperson.
Okay. And thank you very much once again, Ms. Botha, DM and your team for that presentation. Honourable members, do you have any comment and or question that you might have for clarity on the matters that have been presented? If you can just give me an indication. Okay, if not, perhaps just from my side, there's just two issues. The one around, well, the fact that the bill does address the identified constitutional defects identified in the Constitutional Court judgment. But just in terms of the broad definition, I think I find it acceptable for the purposes of this bill, as it will ensure that all affected Muslim women that are left destitute can approach a court for assistance, irrespective of which sect and or denomination they follow. But also bearing in mind that the Department of Home Affairs is developing a comprehensive marriage bill, which obviously will have a consequential effect on this bill. The second issue, DM, I think it's just in relation to the retrospective application. While I know we've received the research document, but just to clarify the matter probably further for ourselves, I'm not sure if you could perhaps give us also, take us through the research document as briefly as you can. I know your department's comments do cover some of the salient points, but perhaps if you could just do that so that we complete this process and in the next meeting take the process of this bill further. DM or Ms. Botha, I'm not sure who'll be doing that.
Yeah, maybe to start, but Ms. Botha did the research notes, so she'll take you through it. But the bottom line, I mean, Women's Legal Centre brought the case. I think they, and Ms. Botha can just confirm it, give more details. They had asked the Constitutional Court to make it retrospective to an earlier date. The court didn't agree with that. They're still pushing the issue, and they may want to litigate further on it. But the concern is, from the department broadly, is that these would be marriages that ended some time ago, before or after 27 April 1994. So it's a bit difficult to unscramble the egg, because it's no longer just between the ex-husband and the ex-wife, but those assets may have been disposed of. So hence the limitation was only to people who'd indicated at the time Women's Legal Centre initiated the proceedings that they were going to be challenging the issue of the fact that Muslim marriages were not included in the Divorce Act. So that's broadly the issue. The Act does apply to any marriage that still subsists regardless of when that marriage was entered into. So if it's a 1980 marriage that still exists and then the parties get divorced, this Amendment Act would apply. But if I can hand over to Ms. Buerta, thanks.
Thanks, Chair. I just want to confirm that you are able to see the research notes that I've shared.
Yes, on my side. If any member can't, they let me know. Please continue.
Thanks, Chair. So this relates in particular to Clause 6 of the bill, and that provides as follows. This Act applies to all subsisting Muslim marriages, including a Muslim marriage A, which was terminated or dissolved in accordance with the tenets of Islam, and where legal proceedings for the dissolution of the said Muslim marriage, in terms of the Divorce Act, have been instituted but not yet finalized, and B, which subsisted as at 15 December 2014. The WLC have commented on this clause, and that was covered in the previous document, the comments and response document. But for the sake of completeness, their issue with this clause is that the constitutional violation is so onerous, the women affected so vulnerable, and the period which they have been the victims of deprivation of rights so lengthy as to justify immediate retrospective relief to 27 April 1994 to the widest possible group of women, and that unintended consequences can be dealt with by a court on application, and that there have been no major unintended consequences when the legislature extended the provisions of the Recognition of Customary Marriages Act, which affected many more couples, and where questions of law have arisen, these have been dealt with by our courts. The WLC then quotes the cases of Gumede, Ramovi, and AS that firmly dealt with such matters by recognizing the legacy of the past and addressing it within the framework of substantive equality. The department is alive to the concerns of the WLC, and it aims to provide as wide a measure of protection as possible to Muslim women and children in the bill. The department agrees and is of the view that the bill, and thus the Divorce Act, should have retrospective effect for the protection of Muslim women and children on the dissolution of their Muslim marriage. The department recognizes the need to protect and promote the rights of Muslim women, of vulnerable women and children. And for this reason, we've suggested the insertion of Clause 6, and that provides for prospective and retrospective application directly. So the issue is thus not whether the bill, and thus the Divorce Act, should have retrospective application. It should. The issue is what restrictions, if any, should apply to the retrospectivity. There are countervailing considerations for Parliament to take into account in the processing of legislation that has retrospective effect, and in particular, the rights and interests of third parties who could be implicated. And it's this balancing of rights and interests of Muslim women and children and the rights and interests of implicated third parties that has to be closely considered. And so the department has submitted this research note to address that crisp issue and to assist the Select Committee in its deliberations, and so that the legal position on retrospective legislation is more fully explained. The rationale for Clause 6 of the bill lies in the WLCT case, and in particular, the interim measures specified in the order of the Constitutional Court in that case. Paragraph 78, which I covered in the department's response document, and that is set out below in this research note, is particularly instructive on this issue. So clause 6 provides for the application of the bill, and thus the application of the Divorce Act, and it will apply to 3 categories of Muslim marriage. They are Muslim marriages which subsist at the time the Divorce Amendment Act comes into effect, that is prospective application. 2, Muslim marriages which no longer subsist because of dissolution in terms of the tenets of Islam, but in respect of which civil proceedings had 1, been instituted, and 2, not been finally determined at the time that the Divorce Act comes into effect, that is, retrospective application, and 3, Muslim marriages which subsisted as at the date when the application was instituted in the High Court, being 15 December 2014, that is, retrospective application again. So the department recognizes 2 forms of retrospective application, each with their own requirements, and limits the scope of their application. The first form of retrospective application has no date restriction and applies to a Muslim marriage dissolved in terms of Sharia law at any point, but which can only apply if civil divorce proceedings had been instituted and had not been finally determined at the time that the Divorce Amendment Act comes into effect. The second form of retrospectivity does have a date restriction, but does not require the marriage to have been dissolved in terms of Sharia law. So it can apply to a Muslim marriage which subsisted as at 15 December 2014, regardless of whether or not that marriage had been dissolved by Sharia law subsequent to that date or not. Retrospective application is limited to balance the rights and interests of Muslim women and children and third parties, and to limit potential unintended consequences. The department, in drafting clause 6, considered a wide range of possibilities, and it settled on crafting a clause that attempts to straddle and balance the rights and interests of Muslim women and children, and the interests and rights of other persons who are and who may be affected by the dissolution of the marriage. And the passage of time following the dissolution of that marriage was a key consideration for the department. In particular, the department considered the impact that retrospectivity may have on claims for redistribution of assets and forfeiture of patrimonial benefits. It was considered whether the parties to the now dissolved marriage have, for example, remarried, sold assets, purchased assets, encumbered assets, may be in a different financial position than they were during the subsistence of the marriage, whether worse or better off. The department would be hesitant to open the floodgates of litigation unnecessarily, and the concern is that by providing for retrospective application of the Divorce Act, that although it would provide protection for Muslim women and children of the dissolved marriage, it may also lead to unintended consequences and potential litigation for the parties who may now be involved. This includes, for example, in the case of a remarriage of the Muslim husband, the Muslim women and children of that marriage, and the termination of assets at the time of the marriage, taking into account the potential disposal of assets since the finalization of the divorce, and the passage of time since the dissolution in terms of Sharia law. There is case law on retrospective application of legislation, and the WLCT have pointed out 3 cases, so Gumede, Ramovi, and AS. But the department is of the view that the cases referenced are distinguishable. I'm going to just briefly talk through this. Gumede dealt with, among others, the constitutionality of Section 7.1 of the RCMA, and that provides for the proprietary consequences of a customary marriage entered into before the commencement of the RCMA, that continue to be governed by customary law, and whether the impugned provisions unfairly discriminate against the applicant and other women similarly situated. The court in the Gomede case has been instructive on the issue of retrospective application of legislation. I'm going to just jump down to the parts in bold font. Paragraph 52 of the Gomede case notes that it's important to add that nothing in the order we intend making will affect customary marriages which have been terminated either by death or by divorce before the date of this order. Also, any exercise of marital power before the date of the order we will make will not be undone as a result of this order. And in the Gomede case, the court made the following order. I'm just going to read the bold font. That in terms of section 172(1)(b) of the Constitution, the orders in paragraphs C, D, E, F, G, and H of this order shall not affect the legal consequences of any act done, or omission, or fact existing in relation to a customary marriage before this order was made, and that any interested person may approach this court for a variation of this order in the event of a serious administrative or practical problems being experienced as a result of this order. Ramohovi similarly dealt with customary marriages, while Gomede dealt with pre-RCMA monogamous customary marriages. Ramohovi dealt with polygamous customary marriages entered into before the RCMA took effect. So pre-RCMA polygamous customary marriages, and whether Section 7.1 of the RCMA is constitutionally valid. The Court held that Section 7.1 of the RCMA limits the right to human dignity and the right not to be discriminated against unfairly, and confirmed its invalidity. The court made the following order, and I'm just going to jump down to the part of the Court judgment, which is in bold. The court is therefore empowered under Section 172(1) of the Constitution to make an order limiting retrospectivity. One of the relevant factors on limiting retrospectivity is the disruptive effect that unlimited or minimally limited retrospectivity would have. Limiting retrospectivity helps avoid the dislocation and inconvenience of undoing transactions, decisions, or actions taken under the invalidated statute. Curry and Duval state that the disruptive effects of an order of retrospective invalidity must be balanced against the need to give effective relief to the applicant and similarly placed people. The Court also said in that same case, seems just and equitable, therefore, that the retrospective effect of the declaration of invalidity must be as extensive as possible, but not affect estates that have been wound up or transfers that have taken effect. Regarding transfer, they follow what Bear had said. It seems to me that unqualified retrospectivity would be unfair because it could result in all transfers of ownership that have taken place over a considerably long time being reconsidered. However, an order which exempts all completed transfers from the provisions of the Constitution would also not accord with justice or equity. It would make it possible to reopen a transaction even where the heir who received transfer knew at the time that the provisions would purport to benefit him or her were yet to be challenged in a court. I'll skip down to paragraph 65. The proposed relief traverses terrain that is fraught with imponderables. I cannot discount the possibility that, despite the effort that has been made, someone may suffer harm not foreseen in this judgment, and it is for an interested person to approach the court for a variation of the order. AS is the final case which the WLCT referred to in its comments, and AS dealt with the provisions of the MPA and its constitutional validity to the extent that it maintains the default position established by the Black Administration Act. The effect of those provisions were that couples who were married subject to the BAA would remain married out of community of property unless they opt to change their property regime to in community of property. A8 is a High Court case, and the High Court stated, again, reading the font in bold, however, the order should not affect marriages which have been terminated by death or divorce before the making of this order, but a saving provision or generic order should be made in favor of a party claiming specific prejudice arising from the retrospective change of the matrimonial regime to approach a court for appropriate relief. I'm going to skip ahead. It's also in the WLCT case, the court dealt with that very extensively, and that ranges from the High Court decision, which went up to the SCA and which went up to the Constitutional Court. I just want to skip down to the parts in bold. This court has been reluctant to make orders that have a disruptive effect. In Ramahovi, this court, recognizing the discrimination at issue, which warranted retrospective application of constitutional invalidity, acknowledged that limiting retrospectivity helps to avoid dislocation and inconvenience of undoing transactions. The court also, in the WLCT case, said that there is a need to strike a balance, and the balance is this. And you will see that that wording is replicated in clause 6 of the bill. Ultimately, the department's concern on retrospectivity is not ameliorated by the alleged size of the Muslim community. The above cases have shown that the consequences of retrospectivity reach beyond what may be envisaged. Thus, the consequences don't only impact the parties to the marriage, but also the wider pool of those who may be involved or affected. There are also other cases on retrospectivity coming out of the SCA. I'm not going to go through these. Sitole coming out of the Constitutional Court as well. Also recognizing that the order must not undo completed transactions, in terms of which ownership of property belonging to any of the affected spouses has since passed to third parties. And then there is an article on retrospectivity, which I'm not going to go through either, but which is set out below. Thanks, Chair. That brings me to the end of this discussion on the research note on retrospective application of legislation.
Okay, thank you very much, Ms. Buerta, for providing more elaborate information on the matter. DM, do you have anything you would want to say? And I think on members, I'm not seeing any indication on whether you have any comment and a question. Perhaps DM from your side?
Yeah, look, from my side, Chair, I think we responded to your question on the retrospectivity. Just to emphasize that, again, we said in the original briefing on the bill that the bill is to address the judgment in the Women's Legal Centre case, so that's why it's restricted to Muslim marriages, and the overall review of the marriage divorce system is taking place with the marriage bill of the Department of Home Affairs. Thanks, Chair.
Okay, thank you very much, DM, and your team once again. On members, if there are no other inputs and or questions, then perhaps we will then further deliberate on the bill in our next meeting, and we'll also look into the possibilities of adopting the bill. That being said, on members, we'll then move on to the second agenda item, which is the Cannabis for Private Purposes bill. Members will also recall on this bill that we received a briefing from the department on the 15th of November 2023. The bill creates a new legal framework to govern cannabis for private use by adults and alternative means to deal with children and cannabis users in line with our constitution and the Constitutional Court judgments handed down in Prince and the Center for Child Law in 2018 and 2022, respectively. This bill was also advertised for public written comments from the 30th of November 2023 to the 19th of January 2024. The committee received quite an overwhelming response to this bill. We received a total of 46 submissions, including petitions, with 19 of the petitions being of a substantive nature, while the rest were of a more general nature. Members will also have received the relevant documentation in relation to the department's comments to the bill, but members would have also noted that an issue that arose out of public submissions also related to the tagging of the bill, public participation and constitutionality. And I think on this matter also, I'll also request the parliamentary legal advisor to also address these matters after the department provides us with their briefing on their responses to submissions on the bill. Let me then hand over to yourself, DM, and your team to deal with that aspect. And thereafter, I think Ms. Lutz will then come in after the department. DM, over to you.
Thanks, Chair. Just to remind honourable members that this bill is a response to the constitutional case and the order in the Constitutional Court. It is not a bill providing for regulation, and that would be coming. That will be coming from another ministry. However, this bill attempts to go as wide as possible. Effectively, it decriminalizes cannabis entirely by taking it off the Drugs and Drug Trafficking Act. And so any crimes relating to cannabis have to be in this bill. Otherwise, there will be no crimes for cannabis. A lot of the submissions were around, I think, on a misunderstanding, and the officials will go through it, on the fact that there wasn't an express provision for cultivation. Cultivation in the bill is allowed, with a provision that the Minister of Justice will determine the amounts of plants that can be cultivated. So just to highlight that point, I think then let me hand over to DDG Pillay to give it over to her team. Thanks, Chair. Sorry, maybe one other thing, Chair, just also to remind honourable members, this bill has been around for some time. It was originally introduced in 2020. It's been advertised once as an introduced bill in the National Assembly, and then the committee had to go back to the National Assembly on 2 further occasions to have it further re-advertised. Thanks, Chair.
Good morning, Honourable Chairperson, and good morning to the members. Mr. Makulubete and Mr. Dupriya are online, and the presentation will be led by Mr. Makulubete. Thank you.
Good morning, Chair and honourable members, and thank you to the DM and the DDG for the introduction. I will be taking the committee through the comments that we have received and the department's responses thereto. Before I go ahead, Chair, I would like to check if I am audible and if my document appears on the screen.
Yes, you are audible. The document is visible.
Thank you, Chair. Chair, these are a list of the names of those who have submitted to us substantive comments, which we are dealing with in this document. And the Chair, the document is lengthy, about 31 pages. And as the DM has indicated, there are a lot of issues that have been raised to the commercialization of cannabis, which is the matter that cannot be dealt with in this bill by another department that will actually promote a bill that will commercialize cannabis in its entirety. And this bill is actually not the bill to deal with those issues. And there are also a lot of issues that have been raised that we are noting. And because of the length of this document, Chair, I will, with permission of the Chair and honorable members, suggest that I highlight the most issues that will require the attention of the committee in as far as these comments are concerned. So in short, I will highlight those most prominent issues for consideration by the committee, and then maybe there and there skip those that we are noting or those that are a repetition in as far as our responses are concerned. Chair, to start with, Pete has made a submissions to say in the first instance that advocates for cannabis reform are essentially united in the call for the regulatory framework that is similar to alcohol, which is a substance that is widely recognized as more harmful. Chair, this is the issue that will be dealt with, or that is for the national legislation that we are contemplating that will deal with the commercialization of cannabis. It is our view that that legislation may be crafted along the lines that is similar to the legislation that regulates alcohol. Secondly, Chair, it is submitted that the proposed bill appears to deviate from the principles of fairness and equality. Rather than fostering a sense of unity, it seems to echo an ideology that could be perceived as unduly restrictive. Chair, the submission goes further to say, as a community, we urge for a more balanced and evidence-based approach that aligns with our constitutional rights and promotes responsible cannabis use, similar to accepted norms around alcohol. David Dobrik and Dylan Pinar do make a similar submissions in most material respects, and the Chair, it is our submissions that they are not specific as to how the bill deviates from the principles of fairness and equality, or even how it occurs an ideology that could be perceived as unduly restrictive. However, the restrictions that we are having in the bill relates, amongst others, Chair, to the prohibition against smoking cannabis in public or in the presence of children or non-consenting adults. Those are the most, although there are other restrictions, but these are the most restrictions that I can highlight at this stage. Chair, we have noted the comments by Terren, and Terren also make further submissions to say that the herb has been used for generation and is not a gateway drug. Cannabis used for adults should be regulated in the same way as alcohol and tobacco. The way alcohol and tobacco is regulated. As I've mentioned, Chair, this is a matter that can be considered for inclusion in the national legislation that will commercialize cannabis. This bill is essentially intended to respond to the Prince judgment and not to commercialize cannabis. We have noted what Andre has said, and Vilma has made a submission, Chair, to say that cannabis already enslaves so many users. Making it legal and available to everyone will potentially risk enslaving more people with the risk of increased criminal activities. However, Chair, Vilma is not clear as to how cannabis enslaves people, but in as far as maybe then it is meant that cannabis will be harmful or addictive, we are of the view and submit that there are institutions that are available to help people who are maybe prone to addiction to cannabis. And as a result, those institutions may be available or are available to assist people in those instances. The bill is intended to comply with the Prince judgment, which gives effect to the right to privacy. Chair, D submits that this should not be allowed at all. That is the legalization. However, the submission goes further to say that we are a drug gang-run state. Cannabis is a gateway to drug abuse. What do you think you are doing with the youth of this country? Chair, it is our submissions that the bill is not the cause of drug use, as cannabis and other drugs have already been in use before. But the bill merely legalizes cannabis to give effect to the adult's right to privacy and does not give children to use or possess cannabis. Chair, another comment says you can't take away our right to grow cannabis, as this is more like trying to tell farmers to stop farming food. As the DM has mentioned, Chair, there's a misunderstanding in relation to the cultivation of cannabis. People are allowed in terms of the bill to cultivate, and the bill does not take away that right. Instead, it gives the effect to that right to cultivate. And in addition, Chair, cannabis cannot be compared to the farming of food, as cannabis was illegal before. A further comment relates to made by Nonhlanhla Mkhize. The submission is that the bill should not be passed if it excludes what benefits the Black people who have suffered a lot by any of the law that make it difficult for them to be able to plant and sell. Chair, it is our submission that the bill applies universally to everyone in the country and does not exclude Black people from cultivating cannabis as submitted. However, the selling of cannabis is strictly prohibited by the bill. Ian objects to not being able to cultivate on his own, as we indicated, Chair. The bill does not prohibit self-cultivation. People are allowed to cultivate in terms of the bill. And even Shannon makes submissions that the bill is rejected. It's an oppression of human rights, especially the disadvantaged, and it is our view that instead, the bill gives effect to the right to privacy as contemplated in the Prince judgment. The next submissions relates to the private social clubs to an extent that they should be recognized as safe and legal spaces for the sharing and cultivation of cannabis, operating within a transparent and traceable framework. This will also support job creation and socio-economic growth. And there's also a submission that there should be a allowance in terms of dealing in cannabis or trade in cannabis. However, it is our submissions that the recognition of cannabis clubs and the trade in cannabis are a matter for dealing with in the contemplated national legislation, as the bill is only intended to deal with the Prince judgment. There are other comments, Chair, that also relates to what our response is saying in terms of the trade in cannabis and the social clubs we can be dealt with in a national legislation that we are contemplating. David, Chair, submits that in the democratic process of enabling legislation, it is imperative within a nation that the government diligently serves the interest of its citizens, refraining from arbitrary decisions. The significance of public input cannot be understated, and proposed bills should earnestly consider such feedback. Chair, it is our submissions that the bill is essentially aligned to the Prince judgment, and its provisions are not arbitrary. The inputs that we receive from the public are considered, as we always do in all the bills that have been promoted. All the comments that we received will be considered by the department and will be incorporated to an extent that they enhance the bill. There's a submission that the legislation, the current legislation delineation of quantities pertaining to cannabis cultivation appears impractical, as it disproportionately favors only highly skilled cultivators capable of harvesting a substantial amount per plant. Chair, the bill does not provide for quantities, as the Deputy Minister has indicated. What the bill does is to leave the determination of the quantities for the in the regulations that will be promoted by the Minister. And in any event, the public comments will be invited when the Minister promotes those regulations in due course. The issue of Dylan is what I have raised, Chair, and the next matter of submission will be that one of Kyle, where he finds it deeply disturbing that cannabis was decriminalized. However, now it is being made illegal again. It is our submission, Chair, that cannabis is not being made illegal again. The bill instead permits the use, possession, and cultivation of cannabis, coupled with penalties for contravention of the provisions of the bill. Penalties are in the form of fines or imprisonment in cases of serious contravention. This is not intended to make the use, possession, and cultivation of cannabis illegal again. Chair, there's also the issues that relate to the old version of the bill in terms of where there was a prescription of 4 plants per adult, but this is no longer the case in the current bill, and there's no restrictions as to 4 plants that are allowed for possession or cultivation by an adult in private. The submission further goes further to say that I also find it disturbing that we, the taxpayers, have to wait for 4 years for clarity on whether or not we are allowed to grow a plant for medicinal usage, as it seems the courts cannot make up their mind. Chair, it is understandable that the processing of legislation takes long, and it depends, among other things, the complexities of the subject matter of the bill. And the Chair, this bill has had its own complexities. And even the Deputy Minister has indicated in his introduction that in the Portfolio Committee, it has been advertised for about 3 times after it was introduced. However, the cultivation of cannabis for medicinal use is regulated in terms of the Medicines Act, and it cannot be regulated in terms of this bill. Chair, the submission of a farmer man is the matter that will be regulated by national legislation, and is a repetition of what has been submitted before. Tsidiso is submitting to say that I'm reaching out to express my strong belief in the potential benefit of enhancing a regulated cannabis industry in South Africa, and to voice my opposition to the current bill that restricts cannabis dealing. As we have mentioned, Chair, the bill responds to the Prince's judgment, and the sale of cannabis is prohibited. Even the Prince's judgment was emphatic to that effect. That is, the dealing in cannabis is a serious offense and cannot be legalized. That is what was held in the Prince judgment. And obviously, as I've mentioned, the national legislation will deal with that. And it's not a matter for this department to deal with the commercialization of cannabis. Submission goes further to say a regulated cannabis industry has the power to be a significant driver of job creation. We have noted this, Chair. Also, the issue of cultural knowledge, we are noting that the stakeholder involvement and transparent business practices, we have noted that, which are matters for inclusion in the national legislation. The indigenous knowledge, we are noting that. And then the creation of industrial economy, which are all matters for inclusion in the national legislation, and they cannot be dealt with in this bill. So we are noted the submission of Riatlehile Youth Chamber. Raz James has a concern that emanates from his previous experience, that he deals with cannabis in terms of producing hair cream, and he also smokes cannabis. And then he says that since 2018, the police have been coming to search his room and arrested him for cannabis that he used for smoking, although he was not selling. But the matter didn't go through to the courts, as the police just released him without pressing charges or going ahead with the charges. But Chair, in relation to this personal experience, it is our submissions that the police are allowed to arrest in certain instances where there is a contravention of the law, such as in selling cannabis. However, if small quantities are possessed for smoking, there will be no need for the police to arrest, because there will be no contravention of the law, because in small quantities, then it is permitted in terms of the Prince judgment, which allows the possession of cannabis in private. A further issue relates to the search of his room for cannabis, and then it is our submissions that a search of premises will be allowed through a search warrant. And then he's saying that he was subjected to this treatment because he's a Rastafari, and it is our submissions that, Chair, the person cannot be searched just for the fact that he or she is a member of the Rastafari community. Chair, we are noting the submissions of Jamie as cannabis will give effect to job creation, and that will be a matter for national legislation. And the bill does not permit a trade in cannabis. We have noted the submission by a Growing Green Club, which says that there must also be laws introduced that can build a whole cannabis industry, and the national legislation will cover this, as I've mentioned before. It is further submitted that further criminalizing of cannabis will only cripple the potential of the cannabis industry. Chair, it is our submissions that cannabis is not criminalized further. As I've mentioned, the bill does not provide for quantities for cultivation, possession, or transportation, as this will be determined in the regulation by the minister, and the comments will be invited in respect thereof. The buying and selling of cannabis is strictly prohibited by the bill itself. There's an issue of arrest by police, and as I've submitted, Chair, the police may not just arrest anyone for possession or cultivation of cannabis that is sufficient for personal consumption, because this is what the Prince judgment ruled, to allow people to possess, use, or cultivate cannabis for personal consumption, and specifically in private. There's an issue of police corruption, which we submit here is a matter for referral to relevant authorities, including IPID. The issue of plant counting, in terms of which the understanding is that different people have different needs, and there are many different plants with different properties. It is therefore impossible to say how many plants any one person may have or need. As I've mentioned, the quantities will be determined in the regulations, and the comments will be invited in respect thereof. There's an inquiry as to who is going to be burdened with the task of enforcing the counting of plants and to what end. This is the duty of the police, which is essentially to enforce compliance with the bill, where there is suspicion of contravention of its provision. This will be to ensure compliance with the provisions of the bill. There's a submission further that my space is private. It should not be invaded for the purposes of counting plants. It is our submission, Chair, that where there is evidence of contravention of the bill, the police will be empowered to enter the premises to investigate such contravention. There's a submission by COSATU to the effect that the bill appears in many instances to reflect a level of contradiction between different departments in government. It seeks to legalize the use of cannabis, yet it places significant restrictions in that regard. It is our submissions, Chair, that although the bill aims to legalize cannabis, there must be conduct that cannot be permitted. For instance, the smoking of cannabis in public or in the presence of children or non-consenting adults is a conduct that must surely be restricted, and which is what the bill does. Chair, the submissions received from Inkwazi matter for commercialization, as the bill does not intend to commercialize and the national legislation will deal with the issues of commercialization of cannabis. There's an issue of aligning the bill with the Cannabis Master Plan. It is our submission, Chair, that the Cannabis Master Plan that is developed by the Department of Agriculture is geared towards the commercialization of cannabis, whereas the bill is a response to the Prince judgment that is aimed to provide for personal use of cannabis in private. The submission of Polly also relates to the commercialization of cannabis, and the bill does not cover that because it is the national legislation that will deal with that. We have noted the submission of Doctors for Life to the effect that cannabis causes permanent irreversible harm to the children. The Concerned Youth Chair raised a concern that the traditional leaders or the National House of Traditional Leaders were not consulted in the promotion of the bill. And it is felt that the bill did not contain, because of the understanding of the concerned young people, to say that it was felt that the bill did not contain provision pertaining to customary law or customs of traditional communities. However, the National House of Traditional and Khoisan leaders has indeed been consulted, and their comments were duly considered by us and even the committee when it processed the bill, that is the portfolio committee. Chair, the comments of the concerned youth people says they have observed firsthand that the decriminalization of cannabis for private use by the Constitutional Court has already created a misconception in the minds of South African learners that dagga is a safe substance that is in fact now legal and may be freely used by adolescents. Chair, the Constitutional Court in the Prince judgment legalized the use, possession, and cultivation of cannabis in respect of adults only, and the bill is intended to give effect to that. Furthermore, in the Center for Child Law judgment, the court decriminalized cannabis in respect of children. And it is our submissions that, Chair, even though it is well known that some children do use cannabis, the court did not give them the right to do so, and the bill also does not give them such right. Chair, there's an inquiry as to how will those the learners who are over the age of 18 who are still at the school are going to be dealt with in terms of the bill as it is proposed. It is our submissions, the Chair, that the learners will be dealt with in terms of the Schools Act, specifically Section 18, capital A1, which prohibits the use or possession of illegal drugs at school premises or during school activities. Furthermore, Section 8, capital A8 permits random tests to be conducted of learners, but in terms of Section A8, capital A14, no criminal proceedings may be instituted by the school against the learner in respect of whom a test was conducted which proved to be positive. Chair, there's a submissions that we should not use our society's most extreme sanction, that is in the form of arrest, to regulate concerns around cannabis in the absence of proof that it is necessary. Chair, it is our submission that the bill permits the use, possession, and cultivation of cannabis, coupled with penalties for contravention of the provisions of the bill. As I've mentioned, the penalties are in the form of fines and imprisonment in cases of serious contravention. The police are indeed allowed to arrest in certain instances where there is contravention of a law, such as selling cannabis. There are matters that are meant for national legislation that will commercialize cannabis in its entirety. The issue of trade in cannabis is also a matter for national legislation, as well as aligning with tobacco and current tobacco and alcohol legislation. National legislation will ideally be aligned with those legislation. The issue of permits for commercialization for commercial cannabis trade is a matter for national legislation. South African National Defence Force have made submissions to the effect that there are far more serious risks to allow members, that is of the South African Defence Force, to use cannabis even privately while in the service of the South African National Defence Force, and especially while on active duty. It is our submissions, Chair, that the bill will be unconstitutional if it were to prohibit members of the South African National Defence Force from using cannabis in their private places. The bill operates equally to all in the country, including the members of the SANDF, even if they are still on active duty. However, the bill does not permit members to use cannabis while on duty. We noted their submission relating to the associated risk. There's an issue that the judgment, that is the Constitutional Court judgment, does not provide an interpretation as to the cultivation, possession, or use of cannabis in private. Does this denote at home, in a private dwelling, or a private place? Chair, I've quoted the paragraph in the Prince judgment, that is paragraph 100, and the Constitutional Court concluded in that judgment to say that, in my view, as long as the use of or possession of cannabis is in a private place and not in public, and the use or possession of cannabis is for personal consumption of an adult, it is protected. Therefore, Chair, it is our submission that the protection applies as long as it is not done in public. Chair, the issue of the live-in quotas, that is the members of the South African National Defence Force do have live-in quotas or official housing, and in those official housing, they are able to live with their families, and that will be a problem for the SANDF, members of the South African National Defence Force. And it is our submissions, Chair, that those living quarters or official housing will constitute the private place of the members of SANDF. And as such, members will have the protection under the bill, unless the policies of SANDF specifically prohibits the use of cannabis within those live-in quarters or the official housing. Essentially, Chair, we are saying this is the matter for the policies to be enforced in terms of the prohibition of the use of cannabis in the live-in quarters. SANDF is of the view that they will be unable, or it will be difficult for them to manage the use of cannabis. by the members of SANDAF. It is our submission, Chair, that the total prohibition of the use of cannabis by members is not a justifiable limitation of the right, just for the mere fact of the inability to manage its use. It is our submissions, Chair, that the remedy for the Department of Defense lies on the prohibition of the use of cannabis while on duty or within the SANDAF premises, and not on the total denial of members' right to use cannabis in private. There are also submissions for a partial exemption of the members of the SANDAF. It is still our submissions, Chair, that the denial of the right to use cannabis by members in private, either totally or partially, will amount to unjust differential treatment of members to everyone in the country just for the mere fact that they are members of the South African National Defence Force. Chair, we have noted the submission of P-Easy Times. There's a further submissions of the unconstitutionality of the bill in both substance and process. The submission is that the substance and the process of the or the current position in as far as cannabis is concerned is automatic as a result of the Prince judgment. It is not something that the submissions to should have been invited for, as the committee has done. The right of an adult to privately cultivate lies at the absolute core of the rights conferred by the Prince judgment. Chair, it is our submissions that the court in the Prince judgment put in place an interim measure which applies until the bill has been enacted. Parliament was required to give effect to the amendments to the Drugs Act, and Parliament is indeed obliged to do so. Hence, it is processing this bill. The bill gives effect to that judgment and also deals with other aspects that need to be dealt with in the legislation. This includes, Chair, providing for penalties for contravention of certain clauses of the bill, as the right to possess, use, cultivate cannabis is not an absolute right, as they are submitting in their submission. As a result, Chair, it was necessary for the committee to invite comments, as the committee has done in this instance. There's a submission, Chair, that the Deputy Minister has alluded to in his introduction, that there seems to be a misunderstanding that the bill essentially prohibits cultivation. It is our submissions, Chair, that this is not the case. We have the annexure that has been submitted to the committee. It lists a number of people who are submitting the very same, or who are putting forward the very same submission, that the bill prohibits cultivation. However, the bill does not prohibit cultivation of cannabis. However, Clause 5 of the bill prohibits the cultivation of cannabis in excess of the number of plants that will be determined by the minister in the regulations. What we are saying, Chair, as the Deputy Minister has indicated, the minister through the regulation is going to prescribe the number of cannabis that may be cultivated, and this is the way the bill anticipates that cultivation of cannabis is permitted by the bill. So the bill essentially does allow cultivation of cannabis. It's just a misunderstanding. Even the field of greens have also got the very same misunderstanding to say that it is of very grave concern to all in the South African cannabis community that the cultivation of cannabis has been omitted from the latest version of the bill. However, it is our submissions that cultivation is not prohibited by the bill. Furthermore, the non-ghost joint is also of the very same misconception that the bill does not provide for the right to cultivate. However, the bill does allow the cultivation of cannabis. The submission by Harambee Chair goes even further to propose that in the preamble, there should be an insertion of the provision that will allow the right to possess, use, or cultivate cannabis by an adult person acting alone or in association with other adults. They have made further submissions in relation to this, Chair. Essentially, they are advocating for the cannabis or the establishment of the cannabis social clubs. Hence, they advocate for the association with other adult persons. It is our submissions, Chair, that the bill does not make provision for the cannabis social clubs, and it is a matter that may be considered for inclusion in the national legislation that will ultimately regulate the commercialization of cannabis in its entirety. However, the bill is confined to an individual adult person exercising their right to privacy in private and not in association with other adult persons. Chair, the Western Cape government proposed the amendment of the definition of a child, that it should be aligned with the definition of that term in the Children's Act, or alternatively, it should be defined to mean a person under the age of 18 years. It is our submissions that the definition of a child in the bill is the same as this one, which says or which defines a child as a person who is under the age of 18 years. This is similar to the alternative proposal by the Western Cape government. Chair, there's a submission fed up by the Western Cape government to the effect that the penalties in clause 411 will apply to a person who merely holds, however briefly, ignited cannabis or a vaping device producing cannabis vapors on behalf of another person. They are inquiring as to whether it is the intention to hold such a person criminally liable, or is the intention to hold criminally liable the person inhaling cannabis or its vapors, or the person assisting such person to do so in the circumstances contemplated in this clause. Chair, it is our submissions that clause 411 will apply to a person who merely holds cannabis for someone else, as it will still cause a nuisance to others who are nearby that person. If this is not the case, Chair, offenders may use it as a defense and they are holding for someone else, and as a result, this provision will be capable of being dodged all the time. People will say, instead of facing accountability, they will just say they are holding it for someone else. Chair, there's a submission for the exclusion of the traditional healers to be able to distribute a small amounts of cannabis as medicine. Chair, it is our submissions that the bill aims to regulate personal consumption of cannabis in private. Cannabis has not been registered for dispensing as medicine in the country, and as such, the bill cannot permit traditional healers to prescribe cannabis as a medicine. Chair, there's an issue of dealing in cannabis, which will be dealt with in the contemplated national legislation. There's an issue of the definition of use of cannabis, which is considered to be vague and does not unpack eating of cannabis. It is our submissions that the word eating carries its ordinary meaning and does not to be unpacked in the bill as proposed in this submission. Chair, you will recall I did talk to the submission by PEZ in relation to the inclusion of cultivate in the bill. They also propose that the word cultivate be included also in clause 2.1. As chair, they are under a misconception that cannabis cultivation of cannabis is not permitted in the bill. However, it is our submissions that the bill does permit the cultivation of cannabis, and it does not prohibit same as proposed. And as a result, it is not really necessary to effect the amendment as proposed, because the bill does permit the cultivation of cannabis. Pete submits, Chair, that the bill is unconstitutional as it offers freedom to use, but yet offers no way for all South Africans to obtain cannabis. And this is contradicting in itself, as not all South Africans have the ability to cultivate. They are inquiring as to how can people cultivate if sale of clones and seeds are prohibited. Chair, it is our submissions that in terms of clause 2.1b of the bill, an adult person is allowed to obtain cannabis from another adult person, but this must be without exchange of consideration. Chair, the Constitutional Court was specific that dealing in cannabis is a serious problem in the country. As a result, it did not decriminalize the purchase or sale of cannabis. Chair, there's a submissions that the clause prohibits an individual from, that is clause 2.1b, from obtaining cannabis for private use through the exchange of consideration, and this is discriminatory, and it is opposed to the principle of fair and equal access, and they are proposing that the expression without the exchange of consideration be deleted from the clause. It is our submissions, Chair, that the Constitutional Court, in the Prince judgment, declined to legalize the sale of cannabis, as dealing in cannabis is a serious problem. Therefore, since the cannabis cannot be sold or purchased, the bill determines the manner in which people can have cannabis, being by obtaining same from others, but not but without paying for cannabis, without paying for getting cannabis from another adult person. However, the national legislation will further deal with this. There is a submission, Chair, that it is highly improbable that those who cultivate cannabis for private use, having spent their own resources and time to do so, will provide cannabis to seekers without the exchange of exchange for consideration. We are agreeable, Chair, that this is a real possibility, but it is also a contravention of clause 4.1 of the bill, which carries a penalty of a fine or up to 10 years imprisonment, depending on the circumstances. A further submissions is to the effect that if prohibitions are placed on the sale of cannabis for private use, there will be no legal pathway for individuals who cannot cultivate their own cannabis or find someone who is willing to provide cannabis to them for free to consume cannabis in private. This is also a reality, Chair, that other people may not have others who will be willing to provide them with cannabis for free. But it is not the matter of this bill, Chair, to provide for the sale of cannabis, but for national legislation to do so, which national legislation will be promoted by another department and not the Justice Department per se. Chair, the issue from the Western Cape government relating to the concealment of cannabis, they submit that there seems to be a disjuncture between the intention of the bill to permit the use by an adult of cannabis for private purpose in the manner that conceals it from the public view, yet in that inadvertently permitting the possession of cannabis in public without qualification. It is our submissions, Chair, that the clause, that is clause 2.3 of the bill, must be read together with the definition of a private purpose, which means that possession must be such that cannabis is concealed from the public view. The legalization of cannabis, as per Priest's judgment, is to permit possession of cannabis for private purpose in private. So there must be that concealment from the public view, and the bill does cover that. A further issue relating to the private social clubs is a matter for national legislation. There's a submission that the bill does not give the consumer the option to smoke or consume cannabis at a licensed bar or premises. It is our submissions that the bill provides for private use of cannabis, and a licensed bar will be a public place as defined in the bill. Chair, there's a submission in relation to clause 3 that deals with the protection of a child, to the effect that we cannot allow a society that wishes to keep the plant hidden from children and young people. We already have a ruling for rural children to be allowed to tend the plants in the garden, and this should filter down through to the rest of the communities. Chair, it is our submissions that evidence has revealed that cannabis has a serious negative public health impact on the youth. However, the children are allowed to assist parents in the cultivation of cannabis, but not to use cannabis. There's an issue also of hiding cannabis from the children, and there's a submission that children of adult users of alcohol and cigarettes live with alcohol and cigarette, etc., being stored and used around the children. Similarly, children of adult users of cannabis should not be isolated from the plant, and they definitely should not be required to, in terms of the proposed bill. It is our submission, Chair, that the bill does not prohibit children from assisting their parents in the cultivation of cannabis. However, the bill does not mean that children are given the right to use cannabis. Instead, adults should exercise should exercise control over children to ensure that cannabis is inaccessible to them unsupervised. The submissions, these two submissions, Chair, also relates to the children, and it is our submissions further that the bill does not prohibit children from assisting their parents in the cultivation of cannabis. The bill aims to protect children from the harms of smoking cannabis, either directly or secondarily. Cannabis has used as health harms to the children than in adults. Even though they can assist their parents in the cultivation of cannabis, they do need to be protected from the harms that could be caused by cannabis. Chair, the inquiry from the Western Cape government is to the effect to say, how will child protection investigation processes be affected by the bill? It is our submission, Chair, that the bill requires that processes under the relevant legislation be followed. It could be processes under the Children's Act, and once that happens, Chair, the matter will be dealt with in terms of that relevant legislation, and then the bill will no longer be applicable in those instances. There's an issue of will the child protection social worker need to conduct a cannabis investigation to determine whether caregiver or responsible adult who use cannabis complies with the law or is offending beyond the stipulated legal requirements. Further screening of foster parents and parents who consume cannabis. Chair, these are matters not to be dealt with in the bill. If a social worker needs to investigate the caregiver or a responsible adult, or to screen the foster parents and parents who consume cannabis, such investigation or screening will be done in terms of other relevant legislation and not in terms of this bill. The issue of prenatal exposure, the impact thereof is not a matter to be dealt with in the bill. Should the bill be enacted, it should be accompanied by a public awareness campaign to inform the public of cannabis-related harms. It is our submissions that the Chair, the department does engage in public awareness campaigns in relation to all new legislation, and this is done in collaboration with GCIS, and this will be done in relation to this bill as well. There's issue of the silence in the bill as to the protection to be afforded to children in the care of guardians permitted to use or smoke or consume cannabis in private. Clause 2 of the bill, Clause 2.2a, prohibits the use of cannabis by adult in the presence of the child. There's an issue of a legislative sentence which they understand to be incorrect. However, having reconsidered the clause, it is our view that the clause is correct as it stands, and it reflects the intention of what is contemplated in that clause. The Doctors for Life submits in relation to clause 3.2b to say that the clause allows for an adult to administer cannabis to a child on prescription by a doctor, even without consent of the child. They submit that in South Africa, there are no cannabis products registered as medication, and they are of the view that this section will cause unnecessary confusion and cause harm to children, and it needs to be removed. It is our submissions that the clause is essentially aimed at protecting children against having cannabis administered to them unless if prescribed by a medical doctor. If cannabis is not registered as medication, therefore no medical prescription prescription can be issued in respect thereof. As a result, Chair, anyone who administers cannabis to a child will be doing so without a prescription and will be in contravention of that clause. Chair, the issue is also raised by the concerned youth people, and it is our submissions that cannabis, if it's not registered, no medical prescription can be issued in respect thereof. Chair, there's an issue of penalties. It is submitted by Pete to say that the 15-year imprisonment penalty and prescribed quantities seem overly stringent. It raises a valid question as to why is cannabis subjected to such strict limitation when alcohol and tobacco are known to have a significant health risks, come with comparatively less restrictions. It is our submissions, Chair, that the period of imprisonment in the bill are the maximums years that the court may impose. It is not compulsory for the court to hand down a 15-year term of imprisonment, and it may be less, but not more than that. Personal circumstances will be considered in each case, and the bill does not provide for quantities, as this will be dealt with in the regulations. And Chair, I must indicate that the bill does not provide for a 15-year term. Instead, the highest period of imprisonment that may be imposed by the bill is a 10 years imprisonment. There's an issue of 10 years imprisonment, which we submit that it is the maximum imprisonment term that may be imposed by the court. Also, a 15-year term is also raised by David. The issue of South African police comes again. It is submitted that the fines proposed in the bill will likely lead to the continuation of unlawful action by the South African police against South Africans in possession of or using cannabis in private for private purposes. It is our submissions, Chair, that the fines are imposed in instances where there are contravention of a certain conduct that is prohibited by the bill, and the police will be entitled to arrest in those specific instances. A further submissions is to the effect that while 2,000 is a relatively affordable amount for most middle class and upper class South Africans, this amount remains significant for the poor. The majority of the country's poor will not be able to afford such fines and will be unfairly incarcerated for years should their cannabis for private purposes be deemed to be for trade. Chair, it is our submissions, as I've mentioned before, that these are the maximum, the bill provides for the maximum amounts, and the court will judge each case in accordance with its own merits. But the bill prohibited conduct that has to be, but the prohibited conduct has to be penalized, and no conduct will be left unpunished for the mere fact of the inability to afford payment of a fine. It is further submitted that the harms against children whose parents have been arrested for their private use of cannabis will be devastating. Chair, it is our submission that even though the children will be affected by the incarceration of their parents, the prohibited conduct could not be left unpunished for the mere fact of the incarceration having a negative effect on the children. The court will consider personal circumstances of the offender when imposing a penalty. There are many other acts, Chair, that provide for incarceration, and parents are not spared imprisonment for the reasons that they have children. Chair, there's submissions that is made by Consultu, which are matters for national legislation that will deal with cannabis industry, cannabis and hemp industry in its entirety. Also, the imprisonment, the penalty of 6 to, or the reduction thereof, I beg your pardon. The reduction of penalty from 6 to 3 years is welcome, but nonetheless is still going to serve as a serious discouragement for those seeking to legally enter the industry. Chair, it is our submissions that the court, as I've mentioned, will determine each case, the penalty in light of the circumstances of each case, and the bill proposes the maximum penalties that may be handed down by the court. The issue of the penalties having negative effect on the children, that it is not to the best interest of the child. It is our submissions that even though children will be affected by the incarceration or the fining of their parents, the prohibited conduct could not be left unpunished. And as a result, parents cannot be spared imprisonment because of the fact that they have children. The Western Cape government submits that clause 4.3 criminalizes the failure by an adult person in possession of cannabis in a public place to store such cannabis in a secure space that is inaccessible to a child as contemplated in section 3.3. However, section 3.3 does not contemplate this scenario, which appears to be a mistake. It is our submissions, Chair, that clause 3.3 is not a mistake, as a cross reference thereto in clause 4.3 relates to the taking of reasonable measures to ensure that cannabis is inaccessible to a child. The clause is also correct to an extent that it covers also any other child, whether under the authority, supervision, or care of an adult person or not. The bill does not make it an offense for an adult to engage a child in cultivating cannabis. Chair, it is the intention of the bill to not penalize an adult person who engages a child to cultivate cannabis, as there are communities that cultivate cannabis for business, and the children are permitted to assist and learn in the family business. And Chair, in terms of this business, we are not essentially referring to the business of sale of cannabis. We are referring to the business that will be permitted in terms of the permits that will have been issued in terms of the medicines or the Plant Improvement Act. Chair, there's an issue that will be dealt with by national legislation. The Doctors for Life, in relation to the penalties, they are submitting that the maximum imprisonment of 12 months or fine of 2,000 is grossly inadequate when considering the harm done to minors by cannabis exposure. Chair, it is our submissions that when the bill was promoted in the portfolio committee, there was a proposal for the reduction of the penalties that were proposed when the bill was processed in the portfolio committee. And hence we have reduced the penalties that may be imposed. And it is our submissions, Chair, as I've submitted, that the court will determine the suitable penalty on a case-by-case basis. It can impose a fine or a prison term, or even both, depending on the circumstances. Chair, there's an issue of the bill as raised by the concerned young people, to the effect that while the bill provides for penalties for any adult permitting a child to possess or use cannabis or causing a child to ingest cannabis, one need only think of a child living in a home where parents and siblings smoke or vape cannabis in their so-called private space. Chair, it is our submissions, and this relates to the secondary smoking. All reasonable steps have been taken to propose measures that are aimed at the protection of children, including the prohibition against smoking in the presence of the child. However, Chair, it should be appreciated that the enforcement of provisions that are aimed at curbing or prohibiting second-hand smoking will, amongst others, be extremely difficult to enforce. Chair, the issues of penalty are repeated here, which we are of the view that each case will be dealt with in terms of its own merits on a case-by-case basis. The issue of the expungement, the Western Cape submits that the word compelling is used in the draft to indicate that compelling reasons must be furnished to the Director General to prevent the revocation of an expungement of a criminal record. Chair, it is our submissions that the Criminal Procedure Act has got a similar provision in section 271DA, and to remove the requirement as suggested will create differences between the requirements under this bill and the Criminal Procedure Act. Under the regulations, it is submitted by Sister V to say that it is imperative to amend your intention for plant counting or prescribed quantities. Chair, as I've mentioned, the issue of quantities will be dealt with in the regulations that the minister will be promoting in due course. It is our submission, though, that the Prince judgment legalized cannabis to the extent that it is sufficient for personal consumption in private, and the regulations will determine those quantities. The concern is raised as to how the minister may amend the regulations with no indication of public consultation. It is proposed the insertion of a provision that is similar to Section 6.3 of the Tobacco Control Act, which obliges the minister to publish the proposed regulations at least 3 months for public comments before issuing those regulations. Chair, it is our submissions that the minister will ordinarily invite public comments on the proposed regulations, even if there is no specific provision in the bill that makes it compulsory to invite public comments like it is the case in the Tobacco Act. In relation to the schedule, Chair, the submission from Alice is to the effect that cars are private spaces and serve as private dwellings for those who find themselves without homes. Individuals occupying the driver's seat of the car with no intention to drive should be allowed to safely use cannabis without fear of arrest. Chair, it is our submissions that the smoking of cannabis in a car whilst in public is not permitted. To permit such a conduct, Chair, could have unintended consequences of people having to drive after having smoked cannabis in those instances. Fields for Green raised another concern to say that the proposed amendments to the National Road Traffic Act having THC but not cannabis retrofitted into the penalties. There is a concern as to how these measures will further undermine the rights of cannabis users. It is our submission, Chair, that the Road Traffic Act prohibits the driving of a vehicle whilst the driver is under the influence of a drug having a narcotic effect, which includes cannabis. The rights of cannabis users will not be undermined by these amendments, as they will ensure that a car is not driven on a public road whilst the driver is under the influence of cannabis. It is submitted that cannabis leads to a marked increase of motor vehicle accidents and fatalities. Drivers under the influence affect children who are pedestrians, passengers, or illegal drivers. We are noting this submissions, Chair, as it supports the proposal in the bill to the effect that they amend the Road Traffic Act. The concerned young people of South Africa submits that it remains to be established how the driving under the influence of cannabis in South Africa is to be avoided, policed, and how the cost involved in testing for the presence of cannabis in the system of road users are to be funded. It is our submission, Chair, that the aim of the bill in amending the Traffic Act to include cannabis is intended to penalize drivers for driving under the influence of cannabis. It will be policed the way driving under the influence of cannabis is being policed. The funding for the test kits will have to be budgeted for and secured, like it is the case with the test kits for alcohol testing. It is submitted, or it is believed that the Department of Transport is not adequately equipped to deal with the increased burden of testing for and policing of cannabis road users that the bill will place on them. Chair, it is acknowledged that there may be challenges in the implementation of these amendments, and the Department of Transport will be engaged before the bill is put into operation. The amendments to the Traffic Act may, if it comes to that, Chair, be suspended and put into operation only at a later stage when the full implementation of the amendment is feasible. Chair, this is the second last page. It is submitted that while Section 48C of the bill makes it an offense for an individual to smoke or consume cannabis while in a vehicle or on a public road, this provision does not address those who smoke or consume cannabis privately before entering and driving a motor vehicle on a public road, thereby jeopardizing the safety and lives of innocent road users and their families. Chair, it is our submission that the bill permits an adult to smoke cannabis in private, but when that adult goes ahead to drive under the influence of cannabis, the provisions of the Road Traffic Act will kick in and become applicable in those instances. Chair, I do apologize. I think this submission is misplaced and does not belong here. Be as it may, it is submitted that the bill in many cases makes no stipulation as to the value of fines that may be imposed for offenses, and that the fines which stipulated appear to be extremely low, and we consider these provisions to be deficient as a result. Chair, it is our submissions that it is not wrong for for the bill to leave the value of fines to be determined by the court, and this will be determined by the court on a case-by-case basis. Chair, this essentially deals with the clauses relating to the penalties, where we said the court may impose a fine or imprisonment to maybe 2 years or 10 years, as the case may be. And in those instances, we didn't stipulate a fine because we are leaving that for the court to determine a fine in instances where the bill provides for a fine or an alternative of a penalty of imprisonment. Chair, this brings me to the conclusion of my presentation, and I thank you.
Thank you very much, Mr. Mukulubete. Members, I think this has been quite a lengthy presentation, but as I indicated earlier, that we'd also get Parliament Legal Services to deal with the issue of the tagging of the bill. And Ms. Lewis, if you could deal with that matter, and if you want to add, in addition to what the department also said around the issue of constitutionality and public participation, if you want to add to that, you may do so as well. Ms. Lewis, we can take that presentation, and then thereafter, honourable members, we can agree around whether we continue deliberation now or whether we can deal with it in the next meeting. Ms. Lewis?
Good afternoon, Chairperson. Thank you so much. Best wishes to you and the committee members for the new year, with this being our first meeting. Chair, I'm going to be very brief. I think colleagues from the department have sufficiently dealt with the details of the bill. And I actually just want, on the tagging issue, I think a Deputy Minister set the tone for the response to this in saying that we must remember that this bill is a response to the Constitutional Court's judgment, which is the focus of that is the decriminalization for private use of cannabis. And in that, I note that one of the submissions had a concern that saying this bill needs to be 76 because there's commercialization, there's regulation, there's environmental and licensing issues. And I think, as Mac succinctly also said, a lot of the submissions are misunderstanding the scope of this bill. This bill is a first step into decriminalizing cannabis so that there in future can be other departments putting in place legislation relating to the commercialization and licensing and quality that might be sold and all of that. But this bill is not regulating that. And as the courts have told us, when we're dealing with tagging, we don't tag in terms of knock-on effect. So yes, in future, we can see that this bill, in setting opening the road up, will result in other bills coming in and regulating. This bill itself does not do so. So we don't look at the knock-on effects. We look at what this bill is doing, and it's very clearly just decriminalizing cannabis. It's looking at it, it's drawing a distinction between adults for private purpose and, like Mac explained, trying to protect the children, so the best interest of a child is there. And then it's doing so for the adults, so for private purpose. The Constitutional Court's been very clear. We're not allowing dealing and trafficking and all of that. We're just looking at the private purpose use in your own private space. So for that purpose, Chair, our office is of the opinion that the bill is correctly tagged as a 75. The one submission also said that the reason why it should be a 76 is so there can be more extensive public hearings and public comments. Chair, this is the one bill, like Deputy Minister said, it's been since 2022. We've had 4 rounds of public submissions just in the portfolio committee, and now again with the select committee. I do think this is a bill where nobody can say that there was not public submissions. It's been quite extensive, and every time the portfolio committee added something, it was published and public comment was obtained again. So the test for tagging is not whether is not a question of whether 75 and 76, whether the one would give more public participation than the other. The test for tagging is there a substantive impact in a Schedule 4 listed item that is triggered by a clause in this bill. And as far as we can see, no, we've stuck within the perimeters that the Constitutional Court has set. It's regulating cannabis or decriminalizing cannabis for private purpose, with the focus of allowing such for adults, not allowing dealing, and protecting the best interest of the child. I hope that will assist the committee. Thank you, Chair.
Thank you very much, Ms. Lutz, for providing that clarity. DM, I think I'd forgotten to see if you had anything to add after Mr. Mukulubete's presentation. But I'm sure, I mean, we're still going to be processing this bill. We can deal with that. On members, I think given the time, I want to, and the length of the presentations that we received, I want to propose that unless you have a burning issue you want to raise right now, that you do it, but that we then defer further deliberation on the bill in the next meeting that we'll hold. If I can get an indication from yourselves, if that's okay, from members. Okay, I'm not seeing any hand that is being raised. I want to assume that that is acceptable. That being said, members, let me take this opportunity to thank yourselves, to thank the DM, the legal teams from both the department and from Parliament for the inputs into the comments that were made by the public on the two bills. And as a committee, we will, in the next meeting in relation to the cannabis for private use bill, deal with further deliberation on this matter. But thank you very much, everyone, and let me declare this meeting closed. Thank you very much.
Thanks, Chair.
Thank you.